Hey there, small business owners. Welcome to the Tax Talk Podcast, the premier business podcast aimed at unlocking your unique potential. I'm your host, Jared Pallon, and I help my clients do three things: find common sense business solutions, minimize tax and maximize profits, and preserve your legacy. Each podcast episode will dig deep into an everyday problem that small business owners face, and most importantly, explore solutions to these problems. You ready to solve problems? Are you ready to keep more of your hard-earned wealth? And are you ready to preserve your legacy? Let's get to it. What is going on, everybody? Welcome to episode 10 of the Tax Talk Podcast. Your host, as usual, Jared Pallon. It's been a bit of a break since the last episode. I had hoped to put some materials together before Christmas, but unfortunately came down with the flu on the 22nd, and that kind of threw all of my plans right out the window. So I am back in the office a few days now. I've got most of my work kind of sorted out and organized, and able to get back to the podcast and get another episode recorded here for you. So what are we looking at today? Episode 10 is going to wrap up the probate planning series. I've got a number of smaller topics that I want to touch base on. So I've kind of wrapped them all up into one episode. They might be smaller in nature, but still very relevant and important to fully understand in the scheme of probate and estate planning to ensure that you are protecting your legacy and your family going forward. So sit back, relax, and get ready to enjoy some probate planning discussion. So first off, we are talking family law claims and then family property. So first up, when considering adding a joint owner to one of your assets, should you be concerned with a family property claim? In short, you should be. Each jurisdiction in Canada has different laws relating to marriage and common law relationships, which must be taken into account. Some provinces allow for amounts to be transferred to a beneficiary not to be considered family property if the inheritance, whatever that asset is kept separate from other family property that you had initially. Bottom line, always important to consult a lawyer to ensure that your will captures your wishes and adheres to the laws within your province. Next, moving on to family property division. So, do joint ownership changes impact the division of property upon a relationship breakdown? So again, in short, yes. Even if a couple has a domestic contract in place that states that both parties would retain control of the assets that they brought into the relationship, should they separate down the line, a switch to joint ownership during that relationship could have an impact on that agreement. It is important to ensure that you are not adding joint owners to inherited property, as this can eliminate the exempt status under the division of property rules. Again, don't look at this type of planning in a silo. There's other ways to handle the transfer of these assets onto the next generation without just arbitrarily adding one child or multiple children on and running yourself into issues moving that asset on down the road. Whether it is that you're trying to avoid a bit of probate or you're just trying to maybe speed up the execution of the distribution of the estate down the road. So as usual, consult the lawyer. Get your wishes out there on the table, have discussions with your family, and ensure that your will properly lays out what it is that you want done. And I think that's going to preserve the family dynamic as good as it possibly can. Next two topics we are looking at is loss of control and creditor exposure. So, if you were to add a joint owner to an asset, do you end up giving up control? What are the potential implications if you were to do this? So, yes, if you do add a joint owner onto an asset, you do end up losing control of that asset in some degree. So this can result in negative implications when you want to, say, mortgage the property or sell it or deal with it in some other manner down the road. Because now you've got a second or possibly third or fourth party that are now, involved with this piece of property or asset, and they are entitled to a say as to what happens to it, so you can't just make decisions that pertain to it without consulting them beforehand. So rather than giving, up control via a joint ownership transfer, it might be better just to outright sell or gift that property at that point in time. If you're ready to give up control, you don't need any income that comes from that asset. It's probably good just to bite the bullet and get it done with right then and there. Next, moving on to creditor exposure. So again, if you add a asset into joint ownership, does this open up yourself or that asset more specifically to creditor claims due to adding on that new joint owner? Again, yes. It can be argued, down the road that the joint owner was maybe just added in trust, but a potential creditor could, argue that in court and still lay claim to that asset. And this is especially true if the property that you put into joint ownership is real property, i.e. land or buildings, because a creditor has, the ability to then put a lien on that property, which can be very cumbersome to then get off of if you're not dealing with those claims that the creditor has against that new joint owner. So what do we kind of learn from this one? Again, fairly short and sweet, but make sure that you are kind of thinking these decisions through. There's long-term consequences based on the fact that you go and make this decision to put a joint owner on there. What happens with control? What are those dynamics going to look like in 5 or 10 years? And what does this other person, have going on? Do they have some potential, business issues that could translate into some creditor claims and that could be launched against you? Maybe you need some income out of this asset going forward. You don't want it tied up in litigation for, numerous years while you're trying to retire and you just want to take it easy. So keep these things in mind when it comes to adding someone on as a joint owner, especially onto real property. So lastly, we're going to look at the unequal treatment of beneficiaries and disinheriting children within a blended family structure. So looking at that unequal treatment, if I add one child as a joint owner on my asset with a right of survivorship, can this negatively impact my estate distribution plan in any way? In short, yes. If the child is a true joint owner, this will result in that asset being directly transferred to them upon your passing. So this is going to result in the other children not being treated equally under the estate because they're not entitled to ownership of this asset that has passed to their sibling. So typically assets held by adult children are usually just held in trust. However, it is possible for another sibling to, go into court and challenge this. And this can turn into a real mess. If you've got this child holding it, supposedly in trust, maybe they think they actually received ownership because they were helping mom over the course of, X number of years with care and, helping them throughout the remaining years of their life. Maybe they feel that they were entitled to this asset and that's what the parent, wanted for them to have as kind of a, a payment for services rendered for X amount of time. And then you get into this mess where kids are fighting over this asset, and was it held in trust, or was it actually intended to, be passed directly? So adding all of your children can result in similar issues. So say you were to have 2 children, and both of them are added on as joint owner of, say, a vacation property. What happens if child 1 happens to pass away before you do? And then subsequently, you end up passing away not too long after that. In that period of time, maybe you're grieving, you've got a lot going on. You don't go back into your lawyer to update your will to reflect any of this. You don't change any of the joint title on that vacation property. And what ends up happening when you pass away then is that second child that you have is the only one left as the joint owner. So that passes directly on to them. What happens though is if child 1 had kids of his own, they are going to be left out of this, portion of the estate, and that's how you end up having some unequal treatment of beneficiaries. So moving on to disinheriting children in a blended family. Question here is, as a member of a blended family, should I be more mindful of probate planning decisions than, say, a traditional family situation? And I would say definitely yes on this. It is quite easy for a variety of assets to be transferred to the surviving spouse and then to his or her children upon passing, leaving children of the first spouse effectively disinherited from the estate. So the use of a spousal trust in this situation can help mitigate this. Assets can be held in trust. The surviving spouse can use these over the course of his or her lifetime, and then upon passing, then those assets transfer back to the children of the first spouse. And by doing this, you kind of protect your children from that first marriage and ensure that they are not neglected from the estate, whether unintentionally or intentionally, whatever the case might be. So those situations, if the assets and the kind of overall estate value warrant it, a spousal trust of one, particular variety could be a useful vehicle to ensure that you are not seeing some of your kids disinherited down the road. That is it for this one, and I will be back to wrap things up. So that kind of wraps up the probate planning series. Went through a number of different discussions looking at the tax implications, some legal implications, and then just kind of the overall family dynamics that can result from poor probate planning done within a silo. It's always important to consult your lawyer, accountant, and an investment advisor to ensure that your plan is put into place correctly, efficiently, taking in consideration, all of your wishes, any tax implications, ensuring that the jurisdiction and the laws that apply to it are respected and abided by. And most importantly, like I always say, that you're looking at preserving your legacy. Because at the end of the day, if you save a whole pile of tax, but you throw your family into disarray after you pass away, is that really beneficial to anyone? Personally, I don't think so. I would like to see clients, yes, have some sort of plan that is tax efficient in every way possible, but we want to preserve the legacy of your family, the family dynamic, and those relationships going forward. Because at the end of the day, that is really what continues on after you pass away. It's your kids, your grandkids, and what they are able to accomplish after you have gone to the other side. So with that in mind, if you've got any estate planning questions, feel free to reach out to me at the firm here, RHF Accountants. Phone number here is 403-343-7707. Alternatively, my email is Jared, Jared, @rhfaccountants.ca. I'll put all that information in the show notes. feel free to reach out to me. Be happy to sit down with you for a 1 hour free consultation just to go through, what it is that you're looking to do, what assets and investments, your business scenario, whatever's going on, to kind of put together a plan that's going to work for you both now and in the future, and helps preserve your legacy for your kids and your grandkids. That's it for now. Take care. Thanks for listening, and we will talk soon.